right, so this is Chapter 18, restrictions on land use or zoning. So there are two types of restrictions you could have on land use. You could have a private restriction, and that's known as a restrictive covenant, or you could have a zoning regulation. So restrictive covenants are oftentimes found in deeds. They are valid restrictions on your use of land. They are passed from one owner to the next. And these restrictions are enforceable so long as, provided that they do not violate a law or the United States Constitution. In the case of private planning, what happens is that a developer lays out an ideal community, then sells property to the buyers. The deeds conveying the property to the buyers would contain these restrictive covenants and then obligate the buyers to observe certain limitations on their use of land. These limitations can be very broad. So for instance, you could establish setback requirements. You could place requirements on the size of the dwelling or the types of the buildings to be placed there. Since the restrictive covenants are recorded with the deeds, subsequent purchasers are subject to these covenants. The owner of any one of the tracts of land may sue to enforce the restrictive covenant. Zoning regulations, on the other hand, are public restrictions, and we're going to talk about them in just a minute. But before we do, let's look at a real case. In this case, involved a restriction on the use of land at Wintergreen Resort. This is the picture of the property that's involved. And this picture was taken, I believe it was last year. Every year the owner adds new things to their display. There's a Wintergreen's Property Owners Association, and in the deeds to every property owner, there are certain restrictive covenants. I'm going to tell you a little bit about the restrictive covenants, and I also will tell you that Wintergreen is going to have quite a problem enforcing those restrictive covenants because they have not consistently enforced them. All right, so here are the basic facts in the case. This is Norton Bowman's house, and he had a display of certain articles of personal property. And this is what the display looked like when he tangled with Wintergreen Property Owners Association. All right, so the display consisted of 3 cow skulls, 2 pairs of cow horns, 3 neon signs reading Aspen, Key West, and Margaritaville, and a bar and murals attached to the outside of Bowman's residence. Now, also on either side of the deck of his house or in the yard, Bowman displayed a lighted Christmas tree silhouette, the statue of 2 deers, which he had lighted, 5 pastel beach-style umbrellas, 8 lighted wicker deer structures, 7 lighted artificial cactus and palm plants, 8 wooden figures representing cowboys and Indians, and 2 lighted pink flamingos and 2 wooden owls. Now, here are the restrictive covenants that are in all of our deeds at Wintergreen. So the first one says this: no building, fence, or other structure shall be erected, placed, or altered, nor shall a building permit for such improvement be applied for or on any property in Wintergreen until the proposed building plans are approved, blah, blah, blah. This is the pertinent part. So then it goes on, it says, no alteration in the exterior appearance of any building or structure shall be made without like approval by the association. Okay, so again, no alteration in the exterior. Now, the Wintergreen Property Association wanted this to be construed as follows: no items which alter the exterior appearance. You know, they're the ones who wrote the restrictive covenant, so I don't know if you remember this from contracts, but the person who drafts a contract, the provisions in the contract are strictly construed against that person. So if you write a restrictive covenant, then that restrictive covenant is strictly construed against you. So I don't think that Wintergreen can properly maintain that no alteration in the exterior appearance is the same as no items which alter the exterior appearance. All right, so that was their first problem. Second problem is this. Another restrictive covenant that Wintergreen has in the deed says this: no signs shall be erected or maintained on any property by anyone, including but not limited to the owner, the realtor, blah, blah, blah. And they can, they can restrict the size, color, and content of the signs. And then it goes on to say that it shall be the responsibility of each property owner and tenant to prevent the development of any unclean, unsightly, or unkempt conditions of buildings or grounds on such property. All right, so Wintergreen Property Association tried to say that unclean, unsightly, or unkempt meant aesthetically displeasing. Actually, I think it's kind of amusing. I always look at this house on my way up the mountain. It's in the wintertime. It's lit up, and it's anyway, kind of interesting. All right, so does this include aesthetically displeasing? Well, the restrictive covenant didn't use those words. And also, here are the words that they did use, that the owner shall prevent the development of any unclean, unsightly, or unkempt. Now, unclean or unsightly, Webster says that this means, unclean means filthy. It does not mean aesthetically displeasing. All right, so another rule of construction that we learned when in contracts is that ordinary words are given their ordinary meaning. And so that means that unclean means unclean. It means filthy. It does not mean aesthetically displeasing. So did Wintergreen win this one? Absolutely not. So let's look at another one, Woodstream versus Pyack. And this is a case out of Ohio. And there was a restrictive covenant, and the property owner said that it was not applicable to him. The restrictive covenant says this, that no pole for use in connection with television shall be erected on any lot without the consent of the developer. All right, so without obtaining consent, Pyack erected a pole-mounted satellite dish on his house. The developer sued to compel the removal of the dish. Does Pyack have to remove the dish? All right, so he cannot have a pole-mounted dish, but could Pyack mount his dish on the roof of his house? And the answer is yes. You can mount a dish any other way, it's just it cannot be mounted on a pole. All right, so the primary purpose is for the court to enforce the intention of the parties. And so let's consider Carpenter versus Davis. This is the restrictive covenant. No one-story building could be constructed on a lot unless it covers 1,150 square feet. All right, the homeowner in this case did not want to build a house that was that big, and so what the homeowner maintained was that a carport gives him the additional square footage, and so therefore he's in compliance with the restrictive covenant. So the question in this case is this. What is a dwelling? So a dwelling's a structure that people live in, right? You can't live in a carport. You can't live in a storage shed. So in this case, the owner was enjoined, or he was stopped from building the undersized dwelling. You know, we would have a closer case if the additional structure was a heated and cooled, perhaps garage, enclosed garage, but carport is not a dwelling, and you cannot argue that you live in the carport. All right, so let's move on to zoning. So zoning is a public means of regulating land use. And the states delegate to counties and local municipalities the authority to enact zoning regulations. These regulations can control lots of different things. So noise, air, and water pollution, as well as population density. Zoning laws are passed at the local level, and they're part of an overall plan that's adopted by a governmental unit. This overall plan is known as the comprehensive plan. Sometimes it's also called the master plan. Now, the master plan usually includes land use, housing needs, movement of people and goods, and community facilities and utilities. In other words, the comprehensive plan is the big picture, and the zoning ordinance is the details. All right, so speaking of details, here's the next slide. So zoning ordinances can affect lots of different things. You'll be asked one question on the test, what could a zoning ordinance affect? Well, it could affect permitted uses of each land parcel, lot sizes, types of structures that may be built, building heights, setbacks, style and appearance of structures, density, protection of natural resources. And traditionally, zoning ordinances have classified land into these uses: residential, commercial, industrial, or agricultural. These land use areas can be further subdivided. So for instance, residential areas can be designated detached single-family dwellings. They could be designated as semi-detached apartments, or so forth. You get the idea. All right, so let's look at Petition of Carpenter. This case addressed the issue of a zoning law that strictly controlled the location of mobile homes. So mobile homes, we also refer to these sometimes as trailers. All right, so here's the ordinance. It prohibited the placement of mobile homes outside of mobile home parks. The alleged reason that was given is that to protect property values in surrounding areas. However, the rationale behind this was somewhat flawed because mobile homes were not prohibited in residential areas, R1 areas, and R2 areas. So the Board of Aldermen denied Mr. Carpenter's request. Mr. Carpenter had a 92-acre farm, and he wanted to put a mobile home on a small plot on his property for his son. It was protected by some mature trees, and anyway, so the Board of Aldermen denied Mr. Carpenter's request. And so the question is this ordinance 1979 valid? And the court here held that requiring placement of mobile homes only in mobile home parks is absolutely unlawful. All right, next case. And this next case also involves some sort of exclusionary zoning. And so this is 18.1 in your book, Britton versus Town of Chester on page 479. And this is an example of where zoning was successfully challenged. And so the Town of Chester, New Hampshire has a zoning ordinance, and it's been in effect for years, and it provided for single-family homes on a 2-acre lot, a duplex on a 3-acre lot, and it excluded multifamily housing from all 5 zoning districts. Planned residential developments would be permitted to have multifamily structures. Chester consists principally of single-family homes. The majority of its residents commute to work in Manchester, so it's a bedroom community. Chester, at the time of the case, was projected to have one of the highest growth rates in New Hampshire. So Ray Millard, a resident of Chester, owns 23 acres, and he's tried for 11 years to obtain a permit to construct a multi-unit housing complex, primarily for low and moderate income families. He was unsuccessful until he brought a suit that challenged the validity of Chester's zoning ordinances. Can he challenge the zoning plan successfully? And in this case, the court held that a town must provide realistic opportunities to create affordable housing for low and moderate income families. And so for that reason, this zoning ordinance was struck down. So this case, Lucas versus South Carolina Coastal Council, arose after Hurricane Hugo. This was a devastating hurricane that hit Charleston, South Carolina, and the surrounding islands. So the 14th Amendment provides that states shall not deprive any person of life, liberty, or property without due process of law. For that reason, land use restrictions that are unreasonable or arbitrary or confiscatory are considered to be void. Which brings us to Lucas versus South Carolina Coastal Council. David Lucas was about my age. paid $975,000 for 2 lots on Isle of Palms. And he planned to build single-family homes on these lots. So if you've been near Charleston, right near Charleston, there's several beaches. So you would have Sullivan's Island, Isle of Palms. On the other side of Charleston, you have Folly Beach, Kiowa, Seabrook Island. Anyway, very very expensive property in these areas. So David Lucas paid $975,000 for 2 front beach lots. After Hurricane Hugo, South Carolina passed a law, the Beachfront Management Act, and it prohibited David Lucas from building habitable structures on these 2 front beach lots. David filed a lawsuit alleging that it was a taking in violation of the 5th and 14th Amendments. The trial court found for Lucas. The South Carolina Supreme Court reversed, and this case was appealed to the United States Supreme Court. So they spent an awful lot of time and an awful lot of money on legal fees. The Supreme Court held that this did amount to a taking, and the Supreme Court held that a state may not transform private property into public property without just compensation. And so David Lucas was justly compensated. All right, so equal protection of the law. Equal protection under the Constitution says this, that all persons have the right to equal protection. In other words, the Constitution prohibits the states and the national government from treating one person differently from another when there is no reasonable ground for classifying them differently. City of Cleburne versus Cleburne Living Center brings up the issue of whether a zoning law can restrict the location of homes for mentally disabled residents. And so in this case, Cleburne, Texas had a zoning ordinance that prohibited homes for mentally disabled unless there was a special use permit obtained from the city. The Cleburne Living Center applied for a special use permit, and that permit was denied. And so the issue in this case is, can zoning laws restrict homes for the mentally handicapped? And the answer is no. The zoning law was a denial of equal protection of the law. There's no justification for this classification. Sometimes we have things that are considered to be a non-conforming use, so that when the use of land is in conflict with a zoning ordinance at the time the zoning ordinance goes into effect, it is considered to be a non-conforming use. A non-conforming use has a constitutionally protected right to continue. However, here's the deal. If it is discontinued for 6 months, then that constitutionally protected right to continue is lost. It cannot be resumed. So the bottom line is this: the right to a non-conforming use may be lost by abandonment. Let's look at a quick hypothetical. So let's say that you own a bar on High Street, and we're going to call the bar Mulligan's. And Farmville passes a zoning regulation that says no bars on High Street. Now, you are now a non-conforming use, or your business is now a non-conforming use. May you continue? May you continue? And the answer is yes. All right, but let's say this. Let's say that you decide that you want to renovate Mulligan's, and so you close down for renovations, and your renovations are completed 7 months later. Now can you reopen in that spot? The answer, of course, would be no, because you lost your right to continue with your non-conforming use. Money versus Zoning Board of Haverford. Let me let you take a closer look at this one. And so Money applied for a building permit to replace an old non-conforming use. It was a garage / chicken coop, and he wanted to place there a new non-conforming use garage. The town denied the application. Money appeals, and the issue in this case is, did the landowner abandon the non-conforming use? Well, in this case, unlike the hypothetical I just gave you, the town did not establish that the landowner failed to use the garage / chicken coop for more than 6 months. The court allowed the landowner to replace a non-conforming use with a similar non-conforming use. and recognize that courts have permitted landowners to demolish nonconforming structures and replace them with new nonconforming structures, and this has been the state of the law for a long time. So if you have a piece of property that has a shed on it, make sure before you tear it down that you do not want to replace it with anything, and that you could if you wanted to, because once you've torn down that non-conforming use, you may not replace it. Variances and conditional use permits. Virtually every time a zoning ordinance is enacted, some property owners are inconvenienced, and maybe they want to change the use of their land. Generally, owners may appeal and ask for something called a conditional use permit. This is also known as a variance, to allow a use that does not meet current zoning requirements. So a conditional use permit is usually granted to a property owner to allow a special use of the property that's defined as an allowable or conditional use within that zone, such as you could have a house of worship or a daycare center in a residential district. A variance permits a landowner to use his land in a manner that is strictly prohibited by the existing zoning. So the administrative agency that is charged with enforcement of zoning laws may grant a variance or may grant a conditional use permit granting the owner permission to use the land in a specified manner. There must be a public hearing before the variance or conditional use permit is granted, and the zoning board will generally not grant a variance when neighboring property owners object. The allowance of an individual variance could constitute spot zoning, and that's illegal, thus their hesitancy to always grant these requests. So landowners may be able to obtain a variance from zoning laws if they can show undue hardship, if the zoning is enforced, or granting that variance will not excessively disrupt surrounding land or the master plan. So let's consider Panica versus Volker. So the local zoning ordinance required that every lot have a minimum number of feet or a street frontage. The owner of a lot that satisfied the requirement sought to subdivide his lot. Now the question is, he'd like to subdivide it into two smaller lots because two smaller lots would be worth far more than one single lot. So the question is, should this variance be granted? And the answer, should the variance be granted in this case, is absolutely not. All right? So that's it for zoning. Next class, we'll talk about constitutional restrictions and fair housing. Thank you.